This is the oral summary of the judgment which is being handed down today in the case of Dr. Julia Duval and 11 to 13 Randolph Crescent Ltd. The appeal raises an important point of principle concerning the meaning of a small group of clauses which are commonly found in the leases of flats in apartment blocks. The question is whether the landlord of a block of flats is entitled to grant a license to one leaseholder to carry out works to his or her flat, which, but for the license, would be a breach of a promise by that leaseholder, when all of the other leaseholders are entitled, under the terms of their leases, to require the landlord to enforce that promise. The point arises in a dispute between Dr. Julia Duval, who is the leaseholder of 2 flats in a building in Randolph Crescent in Maida Vale, and the landlord, a management company, which owns the freehold interest in the building. Mrs. Martha Winfield, the lessee of another flat in the building, wished to carry out substantial work to her flat, and so approached the landlord for its consent. The landlord indicated to Mrs. Winfield that it was minded to give its consent, but Dr. Duval objected. She said the landlord could not give its consent because that would amount to a breach of a promise it had made to her in her lease. The leases of all of the flats in the building are in substantially the same form. They have 3 very important clauses. The first 2 contain promises by the lessee. One of these, clause 2.6, is a qualified covenant which says that the lessee will not carry out alterations, improvements, and additions to the flat unless the landlord has, in advance, given its consent in writing. By operation of law, the landlord cannot refuse to give consent under such a clause, where to do so would be unreasonable. The other, clause 2.7, is an absolute covenant entitled waste, which says that the lessee cannot commit waste, spoil, or destruction in the flat, and cannot cut, among other things, any roof, wall, or ceiling, or any drains, pipes, radiators, wires, or cables. It was agreed that the work that Mrs. Winfield wished to carry out fell within the scope of this clause. The absolute nature of this second covenant does not of itself prevent the landlord from giving the lessee permission to carry out works to which it refers. But the critical question in this appeal is whether, if it does so, the landlord will be acting in breach of a promise it has made in its agreement with each of the other lessees, including Dr. Duval. That promise is said by Dr. Duval to lie in the third of the important clauses, clause 3.19. Clause 3.19 contains 2 promises which the landlord has made to each lessee. First, that every lease of a flat in the building sold at a premium will contain covenants similar to clause 3.19 and clause 2. And secondly, that it will enforce the covenants in clause 2, or similar to clause 2, provided the lessee has undertaken to pay its costs of doing so and has given appropriate security. Dr. Duval says that it is implicit in this clause that the landlord will not put it out of its power to comply with the obligation to enforce clause 2.7 by licensing an activity that would otherwise fall within its scope. Dr. Duval succeeded at trial. An appeal by the landlord to the county court was successful. That decision was overturned on Dr. Duval's further appeal to the Court of Appeal. The landlord now appeals to the Supreme Court. The heart of the landlord's case is this. Clause 2.7 is very broad, and the parties must have realized that over the lifetime of each lease, it was inevitable that the lessee would wish from time to time to carry out routine renovations and improvements falling within its scope. The parties must have appreciated the obvious desirability of allowing the landlord to give consent for works of this kind to be carried out without having to secure the permission of all of the other lessees in the block, a task which might well prove impracticable. If the landlord has granted consent, there is no breach about which another lessee can complain. So it can grant consent for works of this kind to be carried out unless and until another lessee has objected and provided the necessary security. It is the unanimous decision of the Supreme Court that the appeal must be dismissed. Routine repairs and improvements do not fall within Clause 2.7. Such works fall within Clause 2.6 and can be carried out subject to the landlord's approval. Clause 2.7 is directed at activities which go beyond routine alterations and improvements and are intrinsically of such a kind that they may be damaging to or destructive of the building. Put shortly, activities falling within the scope of Clause 2.6 do not fall within the scope of Clause 2.7, not the other way around. It is well established that a party who undertakes a contingent obligation may be under a further obligation not to put it out of its power to discharge the contingent obligation if the contingency arises. Here it is implicit in Clause 3.19 of each lease that the landlord will not put it out of its power to enforce Clause 2.7 in the leases of all of the other lessees by licensing what would otherwise be a breach of its terms. Clause 3.19 serves an important protective function, and each lessee would have known that the landlord would, on satisfaction of the necessary conditions, enforce the obligations that Clause 2.7 contains. It would be uncommercial and make no sense to say, as the landlord does, that Clause 3.19 is deprived of practical effect if the landlord manages to give consent before the other lessee has made an enforcement request and provided the necessary security. The parties cannot have intended that a valuable right held by the objecting lessee could be defeated depending upon who manages to act first, the landlord or that lessee. It follows that the landlord was not entitled to grant a license to Mrs. Winfield to carry out her planned works unless it had obtained the consent of the other leaseholders, including Dr. Duval.